Can NDMC go beyond the terms of the contract to enhance your license fees on the basis of the market value of the property, that too retrospectively? And can they actually terminate your license on the ground of a fundamental breach of contract summarily without even giving you a notice? Well, sadly, yes. There's a ruling from the Delhi High Court Division Bench which allows them to do so. In the case of NDMC versus Bharat Hotels, the case deals with property rights, license fees, and contractual rights of the parties. NDMC had licensed a land in New Delhi to Bharat Hotels Limited in 1982 at an annual license fees of 1.45 crores, which could be revised periodically after every 33 years. In 2020, they suddenly served a notice retrospectively enhancing the license fees and raised a demand of almost 1,063 crores on Bharat Hotels Limited, along with a termination notice terminating the contract on the basis of fundamental breach of contract. The core issues involved in this matter were whether NDMC could actually increase the license fees on the basis of the market value, ignoring the contractual cap of 100%, and with respect to the termination, whether they can actually terminate the contract without giving a notice to the parties. NDMC argued that the cap on the license fees would be saved only subject to the provisions of the NDMC Act, including Section 141 of the NDMC Act, which mandates that a property can be disposed of by the NDMC only on the basis of the market value and to maximize revenue. Whereas, on the grounds of termination, it said that sub-licensees had tried to sell off the property which was sub-licensed to them, which amounted to fundamental breach of contract. Bharat Hotels argued that the license fees was a contract and not a license simpliciter. Hence, the 100% cap on the enhancement of the license fees provided in the contract was valid, as it was not subject to the provisions of the NDMC Act. Further, they said that the termination was invalid because in any case the transaction did not go through and no notice was served on them. The court held that the license deed was a simpliciter license or permission and was not a contract which would be saved by the provisions of the NDMC Act. In any case, since it's public premises, the property must be disposed of for maximum revenue generation only. Hence, the maximum cap of 100% as imposed in the contract was held to be illegal. With respect to the termination, the court held that execution of the transfer agreements in itself was a fundamental breach of contract, and serving of a notice would not have served any purpose for the licensee. Accordingly, the court held both the actions on the NDMC were as per the law. Businesses dealing with government land will be in a constant state of uncertainty and must be ready for unprompted renegotiation of the terms of the contract. Well, the Supreme Court has already granted a stay against the judgment of the High Court, and it will be interesting to see where things go. Thank you.